The first of the judgment, which is very relevant to all of you, is unutilized ITC on export of goods to be computed from shipping date. Revenue rejected the refund claim for the period prior to June 2008. It is a Gujarat High Court judgment. Nitrex Chemicals India Limited versus Assistant Commissioner Goods and Service Tax Division. The second judicial outlook is a Supreme Court judgment, wherein the Commissioner is of the opinion that for the purpose of protecting the interest of the government revenue, assessee's involvement in suspicious and fraudulent payment to certain bank accounts for the wrongful availment of ITC only available for goods supplied to employees as mandated by Section 46 of the Factories Act. Judicial Outlook 4 for today is that today's judicial outlook on GST. My dear friends, today is a very interesting day and many clarification and many judgments have come surrounding GST. The first of the judgment, which is very relevant to all of you, is it is provided as an observation that limitation period for filing refund of unutilized ITC on export of goods to be computed from shipping date. The High Court has clarified. My dear friends, the assessee, in this case, the assessee has filed a refund application on 15/6/2020 for GST paid on export made during July 2017 to March 2018 for the financial year 2017 and 2018. The revenue rejected the refund claim for the period prior to June 2008 as it was time barred under Section 54 subsection 1 of the GST Act. Assessee, however, contended that the relevant date should be considered from the date of filing returns and the delay was due to COVID-19. My dear friends, however, as per Section 54 subsection 1, read with explanation 2, the relevant date for export is the date when goods are loaded for shipping, and the 2-year limitation period is to be calculated from the shipping date. Very, very important judgment, because the shipping date has got a very important significance with respect to GST law, especially with respect to export. So the date, shipping date, the calculation of the day starts from the shipping date. My dear friends, it is clarified there is no provision for the extension of the limitation period. Hence, the refund claim beyond 2 years from the relevant date is rightly rejected and the petition was dismissed. My dear friends, it is a case, it is a Gujarat High Court judgment, Nitrex Chemicals India Limited versus Assistant Commissioner Goods and Service Tax Division, 8 Valsad. In this judgment, they have clarified the position. The second judicial outlook is a Supreme Court judgment, wherein Om Prakash Gupta versus PR Additional Director General DGGI. In this judgment, it was held disposes of challenge to bank account attachment as a matter convergent into final order. My dear friends, the Supreme Court disposed of the special leave petition filed by the assessee against the Delhi High Court order. The Delhi High Court order had upheld the attachment of the assessee's bank account under Section 83 of the CGST Act. My dear friends, for the benefit of all of you, I thought it's relevant that I read the exact provisions of Section 83 of the CGST Act. Section 83 of the CGST Act, I read the exact paragraph. It says, provisional attachment to protect revenue in certain cases. Under that, Section 83 subsection 1 clearly says, where, after the initiation of any proceeding under Chapter 12, Chapter 14 or Chapter 15, the Commissioner is of the opinion that for the purpose of protecting the interest of the government revenue, it is necessary so to do, he may by order in writing attach provisionally any property including bank account belonging to the taxable person or any person specified in subsection 1A of Section 122 in such manner as may be prescribed. This is the bare provision of Section 83. My dear friends, based on this Section 83, they have made a provisional attachment due to allegation of wrongful availment of input tax credit based on non-existent supplier. My dear friends, during the pendency of the SLP, that is special leave petition, a final order under Section 74 of the CGST Act was passed. The assessee was in the process of challenging its final order. The Supreme Court has observed that it need not adjudicate the SLP on merits now. The Supreme Court further clarified that once a final order is passed under Section 74 of the CGST Act, any provisional attachment automatically comes to an end as clarified in the case of Radhakrishnan Industries. However, if the final order under Section 74 is ultimately challenged, it shall be looked into on its own merits. My dear friends, the Delhi High Court, while upholding the bank account attachment, indicated that there is no requirement under Section 83 for the material on the basis of which the Commissioner formed an opinion to be included in the order. Accordingly, the High Court also referred to the factual matrix revealing the assessee's involvement in suspicious and fraudulent payment to certain bank accounts for the wrongful availment of ITC to the extent of 87 lakhs, my dear friends. My dear friends, in this case, the assessee received intimation of the show cause notice only 1 day prior and replied to it. But this reply was not considered. The High Court decided to issue notice on the challenge to the issuance of the show cause notice, acknowledging that the assessee had knowledge of the allegation he was required to meet. This was held in Supreme Court Judgment Om Prakash Gupta versus PR Principal Additional Director General DGGI. Judicial Outlook 3. My dear friends, the Gujarat AAR in the matter of Troika Pharmaceuticals Limited, Advanced Ruling Appeal Number Gujarat GAAR Appeal Number 2025. It has been clarified that the AAR stated that the clarification in Circular Number 172/04/2022, GST on GST exemption for amounts recovered from contractual workers and ITC availment does not apply in this case. My dear friends, this clarification pertains to perquisites provided by an employer to its employees under a contractual agreement which is not applicable here. Accordingly, my dear friends, the AAR, that is Gujarat AAR, emphasized that, my dear friends, ITC is only available for goods supplied to employees as mandated by Section 46 of the Factories Act 1948, which deals with the provision of canteen facilities to employees. This further supports the denial of ITC for the appellant in this case. My dear friends, this is a very, very important clarification provided by Gujarat AAR. Judicial Outlook 4 for today is that order to be set aside as appellate authority cannot reject appeal based on grounds not mentioned in the original show cause notice. Held the High Court. In fact, this is a case of Chhattisgarh High Court wherein Jagadamba Marble versus Joint Commissioner Appeals. My dear friends, for the reference of all of you, the petition is WPT number 20 of 2024. Under this case, very, very important, my dear friends, assessee's GST registration was cancelled. We all know certain times it happens that assessee's GST registration number gets cancelled for not conducting business from the declared principal place. Very important, if you don't conduct business from a declared principal place, there's a possibility that GST registration would get cancelled. My dear friends, the assessee claimed that the business has shifted to a new premises but could not update the address in the GST portal due to lack of knowledge. Physical verification confirmed that the business was operational at the new address. The appellate authority rejected the appeal citing a red alert notice which was not part of the original show cause notice. It was held that the appellate authority cannot travel beyond the scope of the show cause notice and reject the appeal on grounds not mentioned therein. The principles of natural justice were violated as no opportunity was given regarding the red alert allegations. My dear friends, once the defect of non-operation from the declared place was rectified by intimating the new address and verification confirming the business operational there, the registration deserved to be restored. My dear friends, the impugned cancellation orders were set aside and registration was directed to be restored with a condition to file pending returns within 30 days, my dear friends. This is a landmark judgment which is issued by Chhattisgarh High Court in case of Jagadamba Marble versus Joint Commissioner Appeals. That's all for today with respect to Judicial Outlook on GST. Signing off, Advocate Dr. M. Sathya Kumar. Thank you.